Good evening, everybody, and welcome. My name is Christina, and I am with Atlantic Institute. I am just welcoming you guys to Miss Catherine Fleming Bruce. She's our independent dialogue coordinator, and she has put this event together tonight. And so I am going to run the IT backside of it, and she's going to go ahead and host us tonight. So welcome, and I'll let her go ahead and welcome you.
Hello, everyone. I'm sure one or two of you had the opportunity to join us on Sunday for the first part of our discussion on Alexander versus South Carolina NAACP. It's a Supreme Court case that they will be hearing next week on redistricting and racial gerrymandering. So we spent that first part together, just giving an overview of the case. What we want to do today, because our work with Atlantic Institute focuses on dialogue. So we wanted to talk about amicus briefs. We wanted to think about that in terms of dialogue. We wanted to think about amicus briefs as voices representing different constituencies, representing different organizations and different interests that are contributing to the discussion about this case. So in the interest of doing that, we have several guests today who have a whole lot more insight and information about redistricting than I do. And that's what you do, is you go to people who can make sure that they give the best possible explanation. But we're doing this for the public, because there are so many folks who are within these groups who have been studying these issues, but we wanted the general public, as we come to the date when this case is going to be heard, to have a chance to learn more about amicus briefs and what they are and what they do. So my two guests here in the studio, if you want to put it that way, Lynn Teague with the League of Women Voters of South Carolina. We also have civil rights attorney Armand Durfner. He's doing a little work right now, but he'll pop back in a little bit. And we also have 3 pre-recorded interviews that we're going to share with you that are from folks who have been working with these amicus briefs. There are about 15 that were presented, some on the pro side, some on the con side. But what we want to do today is hear a little bit about what exactly is an amicus brief. What does that mean? So Lynn, is that something that you can share with our audience? What is an amicus brief? What is its purpose? What does it accomplish? Oh, need to hear you. She got her on mute.
I'm sure Armand could give a much more professional explanation, but my understanding, as somebody who's been very involved on behalf of the League of Women Voters, is that amicus briefs are intended to add to the arguments that are made in the primary brief, to fill gaps if necessary, to expand on the arguments that are made there, and to reflect the interest of diverse groups that are not primary litigants, but wish to have a say in how this is decided. Now, as I believe Armand will be filling us in on briefly later, DOJ, for instance, Department of Justice, does get involved with these, but usually it's outside organizations. In our case, the League's amicus brief was joined by the Gullah Geechee Chamber of Commerce and the Charleston branch of the Association for the Study of African American Life and Culture, and also the Congregational Church, which has taken a long-standing interest in social justice and economic justice in the Charleston area. And you have to be pretty approved to file an amicus brief as having some voice that's meaningful. With the League's long history in voting in elections and redistricting in South Carolina, and the obvious interest of the folks who were involved with us on the brief, we were able to develop our own contribution there.
That makes sense. And I believe that's called having standing.
Yes, yes.
Okay, yeah,
But we
so
didn't establish standing as primary litigants, although I suspect we would have been able to. But as for an amicus brief.
yes, yes. And Armand Darkner is back with us. Thank you so much for being here today. We opened just to talk a little bit about what amicus briefs are, what they do, and what they're intended to accomplish. And you were going to share with us a little bit about the kind of briefs that really have the greatest impact in these cases. So please.
Well, oftentimes there are organizations that file a good number of amicus briefs, and the court, now there are so many amicus briefs filed in the big cases like this one. So in fact, I think in the affirmative action case, there were probably 100 amicus briefs. So a lot of them will not get as much attention as they should. And the point to make in an amicus brief is you want to tell the court something that may be a little different from what the parties are describing, or emphasize something. So, for example, I'll give a bout to Lynn Teague's organization, the League of Women Voters, I think it's the League of South Carolina and the League of the United States, has filed a very important amicus brief prepared by the firm of Duffy and Young in Charleston, emphasizing one of the key points in the case, which is that the Charleston County is a community of interest, and that the logical thing to do would be to keep Charleston County mostly together, and yet the plan cut Charleston County up, and that was one of the points that the court made in saying this was a racial gerrymander. The legislature went out of its way to divide Charleston County, and they did it according to what the court found was to make sure that Black voters would be heard. So that's a very important amicus brief. The Justice Department is in this case, and that's very important because they have more influence with the justices than anybody else. And part of the reason for that is that the department, of course, has a position, and if they're Republican administration or Democratic administration, that will play a part. But the Department of Justice, headed by, or in the Supreme Court headed by somebody called the Solicitor General, takes great pride in being as impartial as it can be. So they're not just politicians coming in there and saying, we're on this side or we're on that side. And the department here has come in, and what's extra important is that they've not only filed an amicus brief, they will participate in the argument, so that the people arguing for us, in effect, is not only the Legal Defense Fund, Leah Aiden, but also the United States Department of Justice. And that's really powerful. And they're talking about the legal standards and how the court, they've analyzed the court's opinion very closely, and they've shown how the court's opinion is very close to and sticks very much to what the law on this issue is. So those are two very important. There are many other important amicus briefs filed on behalf of some of the people that I think you have recordings with. Nick Stephanopoulos has a very important one. The historians agree with Vernon Burton, Morgan Couser, and others. That's very important because it shows how the history of South Carolina blends into what they're doing today. What they're doing yesteryear is no different from what they're doing today. When South Carolina, when our legislature or governor says it's not about race, we know it's about race. So the historians are bringing a special point of view, the government a special point of, not just a point of view, but a perspective of information. The League of Women Voters is a very important one, and many of the other amicus briefs on both sides. That's what you try to do with an amicus brief, is bring up something that may not have been emphasized, or that you want to emphasize more. It's not just we're on this side and count our votes or count who we are. We want to tell you something that you might not otherwise know.
And that's very valuable. So I want to now hear a little bit from some of our pre-recorded folks who have worked on these amicus briefs. So we're going to start Let me make sure I've got my screen share together. I think I have it together. All right, so here we are. We have a really august panel of historians here today with us, who were a part of putting the Amicus brief together. So they're one of the voices that the U.S. Supreme Court will be hearing as they consider Alexander versus South Carolina NAACP. So I'm going to call on each one and ask you to introduce yourself briefly, and then we'll go into the discussion. So we'll start with Dr. Burton. Tell us very quick who you are.
I'm Vernon Burton. I am the Judge Matthew J. Perry Distinguished Professor of History at Clemson. Spent most of my career at the University of Illinois, 34 years, retired there, and have come back home. I grew up in 96, South Carolina.
Welcome. Thank you. Dr. Carter.
I'm a retired historian, spent, like Vernon, most of my career, not at Illinois, but at Emory University in Atlanta. But from 2000 to 2007, I taught at the University of South Carolina, where I graduated as an undergraduate. And like Vernon, my specialty is Southern history, African American history.
Yes, thank you. Thank you for joining us. Dr. Harris.
Hi, my name is Carmen Harris. I'm a professor of history at USC Upstate, a native of Gaffney, South Carolina, and my specialties are Southern agricultural history and African American history and South Carolina history.
Thank you. Thank you so much for being here. And Dr. Venters.
Hey, I'm Louis Venters. I'm a professor of history at Francis Marion University in Florence, which is the city of my birth by chance. And I teach South Carolina history, African American history, public history, and also supervise our history internship and our public history and archaeology track.
Okay, thank you. Thank you one and all for being here. And I'd like to start by asking, why historians? Because I saw a list of amicus briefs that are about 15 deep, and I saw from historians there. So who can tell me why historians wanted to come together and to be a part of producing an amicus brief in this case?
Well, let me start here since I'm maybe leaving. Everybody knows William Faulkner's statement that the past is the present is sorry. Sorry, I've had a long day today.
Prologue, is it?
The past is very much a part of the present. And you can't really look at what's going on right now and assume that things miraculously changed in 1964 simply by the passage of the Civil Rights Act. Cultural, historical patterns run very deep, and we know that no matter what the law has changed, that there are patterns that continue to affect, particularly in this case, voting rights for African Americans.
Okay, Lewis, what do you say?
Well, I wasn't part of originating this particular brief, but when the opportunity came to me, I jumped on it for a number of reasons. As a professional historian, I mean, part of what I studied and part of what I teach is about the complex interactions between race and politics in American history and in South Carolina history. And so it seems like just as a matter of conscience, you know, to be true to my profession, it's important to put my name when I can on any effort to clarify the history of race and politics in our state and in our society. One of the things that personally set me on the path to accepting the chance to sign on to this brief when it came to me was really, it's closely related. It's the Shelby County versus Holder decision from 2013 that took away the most important provision of the Voting Rights Act of 1965. And I remember, 10 years ago now, learning about the Shelby County decision, and as a historian, what I heard was the basic argument of the state of Alabama was, look at the great Black voter participation that we have in Alabama. You see, we don't discriminate. We don't need pre-clearance anymore. And of course, pre-clearance, that provision of the Voting Rights Act, is precisely why there was good Black voter participation in Alabama. So what I recall from that case was a misuse of history. What seemed to me to be a willful, not just blindness to history, but a misapplication of history on purpose, muddying the waters to try and advance a spurious argument. So historians help this country to know itself, and we have to speak out, especially when it's very much in line with our teaching and our scholarship. This seemed like an important thing for me.
That's so connected to what we're talking about, making sure that people understand and have a right application of history. Dr. Harris, what are some of your thoughts?
So, like Dr. Ventnor's, I did not develop the petition, didn't participate in it, but very much think that historians have an important role to play. This is the second time I've actually signed a petition. I signed the one in, I believe it was like 2000 on the Confederate flag. I was a young scholar at that time. But, when I think back, when we look at Briggs v. Elliott and Brown v. Board of Education, historians were involved in that. C. Van Woodward and John Hope Franklin, both of whom I had the pleasure of meeting briefly, were part of that team that developed the historical argument around that case that destroyed Plessy versus Ferguson. So our knowledge essentially is our power.
That's right. Thank you so much. And Dr. Burton, what are your thoughts on that?
Well, a lot of thoughts. First, I guess I am partly responsible. The LDF reached out to Morgan Kaiser and me and asked us to be the consultants with the attorneys. Now, they did not take all of our arguments, and Dan Carter and I, who served in the Charleston case, probably knows the one that we argued very strongly that should be taken. But they, of course, are trying to win the case, and so they want to follow the lines of the argument. That's one of the things you learn as a historian, because I've been doing this since 1980 in Mobile versus Bolden, is that truth itself, maybe, is not how the law, but as Justice Oliver Wendell Holmes says, justice and the law are not the same thing, but we have to speak truth to power. And I do want to say just briefly, following what Louis said, that's so important, is that in the most notorious, I think almost all the historians agree, if not legal scholars, case of all time, the Harriet Dred Scott decision, the lower court judge, before it went to Supreme Court, argued that things are not as they were, meaning that things have changed. That's almost the exact word that Justice Roberts said with Shelby v. Holder. Things are not as they were. And then in just 2021, Justice Alito, in a notorious case, Bronovich, is actually going after Section 2. And what does he say? Things are not as they were in 1982, referring to when the Voting Rights Act was renewed. And a couple of cases I've done very recently, I sort of shot the attorneys when I said, yes, Justice Alito is right. It's not like 1982. In 1982, everyone agreed people should vote. They were interested in diluting their vote, making sure that minority voters, particularly Black voters, did not have the equal chance to elect people. They weren't trying to stop people from voting. I said, it is like 1898 and Williams versus Mississippi. They're actually trying to stop people from voting now. we have something I never thought would happen, retrogress in the most important fundamental right, the right to citizenship and the right to vote, and to have an equal opportunity to have your vote count. So I think we're in a crisis in democracy, and what we historians have to do is speak truth to power. And secondly, as Dan was saying earlier, the way the court and laws work now, you have to show as part of the way to win these cases is that there is a history of discrimination. And one of the most amazing things about this brief is how this reflects 1870s and after Reconstruction, that interracial period of democracy, of how Black people were disfranchised in. Even the district itself almost looks exactly like the districts that were drawn at that time by Democrats to pack all of the Black voters they could into one district so that whites could control the other. So it's very important on two levels. One, our moral obligation, and secondly, the legal sort of way that you win these cases through the 14th Amendment or the Voting Rights Act requires that you show these things, basically a totality of circumstances, and one of those, or the intent, both of those, is the history of discrimination in voting.
Wow, yes. Well, why don't you tell us a little more about, I think, did somebody want to jump in?
No, I was just going to say that there are many similarities going, as Vernon says, back to the 19th century, but the one absolutely common factor in it is that if you want to disenfranchise people, you can develop all kinds of different kinds of techniques, everything from gerrymandering to, there are dozens of techniques that can be developed. And that is why the free clearance provision was there, but so that the Civil Rights Division of the Justice Department could look at it and say, what's the effect of this? Not whether it's technically exactly within the law or not, but what's the effect of this measure that you're adopting, whether it's going from single districts to at-large districts or any of dozens of other things. And by losing that, you end up having, it's like whack-a-mole, because there's, every time you turn around, there's another way to do it. There's another way to limit the right of Americans to vote. And until we get a process by which, I think there are some states experimenting it now, in which you have a process with everybody's ready to vote, almost automatically. And you get access to the ballot box and you end gerrymandering, we're going to continue to have this kind of enormous discrimination by whichever party happens to have the levers of power.
Now I'm going to stop some of our interviews a little early because I will post them to my page later so people can see the entirety, since we're trying to stick to an hour. But I wanted to give both Lynn and Armand a chance to comment if they care to on what the historians have said.
Go ahead, Lynn. You go ahead first.
Lynn, you just have to unmute.
Go ahead. I was saying,
Keep forgetting. Sorry about that. Yeah, the historians are absolutely right that what we're looking at, things have shifted a bit, but certainly it's absurd to claim that we have moved past all of South Carolina's long, tragic, ugly history. And in fact, what we're seeing in this, in this redistricting is a continuation of the process of ending, trying to dilute the voices of the people that are not in charge. And, this has been going on for so long. And people who know me well know that you don't want to get me started on South Carolina history too much, because I can get carried away. But I know that some of my own ancestors were brought here from Switzerland specifically because the government was afraid there wouldn't be enough white people to drown out the voices of Black people who were being brought in involuntarily. So when we see what's happening with the redistricting, yeah, it's different than locking the door of the polling place or having a poll tax. What it's doing is saying, sure, cast your vote, but we'll make sure it doesn't mean much.
Exactly. Armand?
Yeah, I just thank you. This is a great exercise here, and I appreciate being part of it. I just wanted to take a minute to talk about the legal issue in the case, because the court has really, the Supreme Court over the last few years, and one of our historians mentioned the Shelby County thing, Supreme Court has really stacked the deck. The Supreme Court has said, as I think Dan Carter mentioned, that if black people get hurt, black voters get hurt, but that unless you can prove that was the purpose, that's okay. They have also said it's okay for the legislators to cheat the voters if they're cheating them because they're Democrats or based on political parties. So what the state is saying, oh yeah, we know that black people got hurt in Charleston. We know it was disgraceful and terrible, but we didn't do it to hurt them. We did it to hurt the Democrats, and therefore it's okay. And so the job of our side is to show, as the three-judge court found unanimously, no, they set out to hurt black voters, and the fact that they're now trying to hide behind this political theory, it just makes no sense at all, and it's foreign to the history of South Carolina. That's why I said at the beginning, whenever they say in South Carolina that it's not about race, you know it's about race. So that's what you have to watch when you hear the state lawyers or anybody else saying, oh yeah, sure, we gerrymandered, we did it to hurt Democrats. That doesn't win the case for us. That would lose the case if the Supreme Court believed it, but the three-judge court didn't believe it, and it's not true.
I'd like to add here that we looked, aside from the beautiful statistical analysis that was done with respect to CD1 on behalf of ACLU and NAACP, if you just look at the raw numbers in South Carolina, I testified on this in court, the whole state is really a racial gerrymander. You go from having a population that is about 7% black voting age population up in Pickens and Oconee County. Williamsburg, over 60%. On the coast, we're running 25 to 35% with the below the Santee, with the exception of Beaufort, which they were really careful to throw into CD1 because it's at 17. And so we have this big variation in the actual population distribution, not nearly as much variation in the black voting age population allocated to each of the congressional districts. Aside from 6, which is the Voting Rights Act district, the others are within, I think, something like 7 percentage points of each other in black voting age population. And that, I think, is the product of many of a series of redistrictings over the decades in which they have systematically worked to distribute the black voting age population in such a way that they will minimize the voice.
Vernon Burton talked about it looks like the 1870s and 80s. That's exactly what they did in the 1880s and 90s. They took every black voter they could find, from Pickens to Horry to Beaufort, and put them in one gigantic, bizarre-shaped district to make sure. They knew there had to be one. They were darn sure there was not going to be more than one, although there should have been 2 and 3 and 4.
And that is really shocking to hear, that what we're seeing is modeling the what we call the Reconstruction era. So that bears a lot of attention. So we're going to go to our next clip now. So let me try to get this screen the way it's supposed to be now. Okay, is it sharing?
Okay, thanks to all of you for joining me today.
No, not yet.
Okay, hold on. Okay, now it's.
Yep.
Okay.
Catherine Fleming Bruce, and I'm here with one of our special guests from Harvard University. And I'd like you to introduce yourself and your connection to Alexander versus NAACP, talking about how you got involved in this brief and what the brief is about.
Great. My name is Steve Ansalov here. I'm a professor of government in the Harvard University, and I teach American politics, elections, and have worked for the past dozen or so years as an expert in a variety of voting rights cases, including ID requirements, other kinds of restrictive laws, but also redistricting. And the backstory of the case is that I'd worked on a case in North Carolina that involved a racial gerrymander. It was old North Carolina District 12. Kind of, if you look at an old map of North Carolina, there was a district that kind of snaked all the way through, and it connected the Durham area to Mecklenburg and cut Charlotte up and things like that. So we were able to show that that had been drawn in a racially discriminatory manner and in a way that harmed minority voters, especially Black voters, predominant Black community in that area, but there were some Hispanic voters as well. So we're able to show that the state legislature had done this intentionally because their defense was we did it for partisan reasons, not racial reasons. But we were able to take the demographic data and the voting data, and for every precinct that got moved out of the district and every precinct that got moved into the district, we were able to show that race was the predictor of what got moved in, and race was the predictor of what got moved out, not party. And then there was a case that surfaced in Virginia, and we were able to show the same thing there. And those districts were struck down. That had been a surprise in North Carolina because there had been a case back in the 90s involving the same district, and they hadn't been able to show it. But this time we were able to show this was race had predominated. That's the lingo that gets used. That means that we showed that it was a much bigger and stronger predictor of why something was changed in the district than was anything else, in particular party, which was the state's own defense. So then the South Carolina case came up, and I was not an expert in that case, but the expert in that case was using the same approach that we had used in North Carolina and in Virginia, and then we'd used in academic research concerning the effects of redistricting on different voters and on different politicians. And he had followed exactly what I and others had done. And so we were weighing in on this case to say, this person had done this correctly. He'd reached valid conclusions, and the approaches are generally taken as sound as a way to understand whether race or party predominated.
And that is basically, you're saying you're giving precedent for the evidence that that they're presenting in this case.
Yeah, and then we're also kind of inspecting what he's done and saying, yeah, he's done it right and has drawn the right conclusion. This comes up because in prior cases, the courts had been skeptical about some social science that had been used in court cases like this. And, the expression of sociological gobbledygook had been used in the prior case. The North Carolina case, though, had gone all the way up to the U.S. Supreme Court, and a majority had upheld that. And the Virginia case went all the way up to the U.S. Supreme Court, and the court upheld that. So this was a case where we're saying the same social science that you saw in the prior decade and relied on in striking down those two maps was used here to prove that race was the predominant factor in South Carolina, not party. And, it's hard. Blacks vote. It's hard to separate those because blacks vote so overwhelmingly Democratic in most elections. But what we're able to show is it's not just the way blacks are treated, but the way whites are treated, that the white precincts that are moved out are being moved out because they're white, not because they're Republican.
Okay. So from here, we have some more evidence being presented. And one thing I learned in doing this is that I was saying amicus and I should be saying something else. So I learned that my pronunciation needed some work, but all of us are learning in this process. So I can take a few comments, or I can go to our final clip. And I do have a comment here that says, wow, being moved out because they're white and not because they're a Republican. So yes, race was shown as a very strong predictor in the work that they did and the research that they did. Any comments before I go to the next clip? Okay, so let me try to do this. See if I can get this right. And this is our final clip. Share the screen. Okay, I see now. Okay, not that one. We just saw that one.
You're probably going to have to go back out and then share it again, because I guess we can see the screen that's got the 3 videos.
Okay. There's the screen that I want. Okay. Now, can you see it?
And now we have.
No, go ahead
Okay.
and go. No, but now it's
Gotcha.
up, so now you should be able to go back out and back in.
Okay.
And find it.
There it is. All right.
Another guest is going to come and talk to us about the Amicus brief that he is working on. Nick, why don't you introduce yourself to the audience and talk a little about the institution you're with and how you got involved in writing this Amicus brief.
Yeah, terrific. And thanks so much for having me on the show. It's really great to be here. So I'm Nick Stephanopoulos. I'm a law professor at Harvard Law School. And I wrote this brief on behalf of myself and Joey Chen, who's a political scientist at the University of Michigan. So the background here for Joey and me is that we have a lot of experience using computer simulations in the redistricting context. That just refers to using a computer algorithm to spit out lots and lots of maps for a given state based on whatever instructions we give the algorithm. And so Joey and I have done this in the partisan gerrymandering context. And we've also written 2 articles about the uses of redistricting algorithms in the race and redistricting context as well. So the South Carolina racial gerrymandering case here is really interesting. It's the first one of its kind to reach the Supreme Court, where the parties have used this kind of computer algorithm evidence as one piece of the puzzle, as a way of showing that race predominated in the construction of the first congressional district in South Carolina. It's certainly not the only kind of evidence the plaintiffs had, but it was one useful piece of the puzzle for them. And so Joey and I decided to write our brief to really zero in on this particular technique, the computational redistricting, and to educate the court about how this technique has been used previously and why it's a very helpful technique for shedding light on the motives of line drawers in a given state. So I can go on. That's a bit of background here about the method and Joey and me and why we thought it made sense for us to be the people submitting this amicus brief to the court in light of our prior experience with this method.
Well, I want to talk a little bit about maps because I was involved with some of the organizations that were trying to educate the public more about the redistricting process. And so we did have some folks who learned about map making and so forth. Most of us didn't get that far. So what is it that we need to know about the process of map making and what its purpose can be and how that purpose can be used for good or ill in terms of setting up the final boundaries?
Yes, you mentioned the purpose, right? And the purpose of the map is the most important issue in this kind of a racial gerrymandering case. The big legal issue is whether it was race or something else, like politics, for example, that predominantly explains the shape of the first congressional district. And so the plaintiffs pointed out, hey, look, if you examine the boundaries of the first district, it's trying really hard to avoid pockets of Black population in and around Charleston, South Carolina. It's wiggling in a very strange way that certainly looks like it's trying to artificially suppress the Black population of that district. So South Carolina says, you're wrong. We have lots of non-racial motives for that district. We're just trying to respect county boundaries. We're trying to just districts that look nice. Maybe we even have a political, not a racial motive for this district. As the real power of the computer algorithm is that you can tell the algorithm, okay, do every non-racial thing that South Carolina says it was trying to do. Come up with districts that are just as compact, just as respectful of county boundaries and city boundaries, but don't consider race. And then let's look at the racial makeup of the real District 1 compared to the racial makeup of hundreds or thousands or tens of thousands of computer-generated maps. And when you do that in South Carolina for this map, it turns out that the computer-generated maps always have an equivalent to District 1 with a larger Black population. So the real District 1 has an artificially white, like a less Black population than just about every single one of the thousands of districts that are accomplishing all of the state's non-racial goals. And so the real power of this technique is just to say, hey, look, we controlled for every single non-racial thing we were doing, and we still see this enormous difference in demographics between the actual District 1 and all of the analogs in the computer simulations. That's pretty good evidence that race must have actually predominated when you drew District 1.
My, that's pretty amazing as a piece of evidence. I've heard lots of things today, but that's one that I think is going to really capture a lot of attention. I also want to ask for those who don't know exactly what an algorithm is, what would be a good way to clarify that for them?
Really just a set of instructions for a computer program. We have this computer program that's able to spit out district maps for any state, but you've got to give the computer program instructions. You have to tell it, make sure all the districts have the same population, make sure their compactness score isn't above some level or below some level, make sure you're not unnecessarily breaking up counties or cities or what have you. And so all I mean by an algorithm is the set of instructions that we give to the computer program that then enable the computer program to randomly generate all of these different district maps.
Right. I think that's fantastic, just in terms of all the evidence that I have heard. So are you going to be one of the people who will present this information? Because many people don't really know how an Amicus brief works. So is that just a stack of documents that are given to the court, or is someone arguing in front of the court, and are you or another attorney arguing that in front of the court next week, or how exactly will that work?
Yeah, so in very rare cases, the Supreme Court or a court might ask an amicus to speak. It happens every once in a while, but almost always, 99% of the time, unfortunately, it is just a stack of documents that are sent to the court. So Joey and I, along with quite a few other parties have written these amicus briefs. They're filed with the court, and the clerks and often the justices read the amicus briefs, but we as amici don't have a chance to actually argue in front of the court. We can nevertheless have yeah, exactly. We can nevertheless have an influence. So it's very common for the Supreme Court to cite amicus briefs in its decisions, or even in oral argument. Like both in decisions and in oral arguments, I've seen the court refer to amicus briefs and often find points in those briefs to be very persuasive. So amici can certainly have an influence, even though they're not standing up and speaking in front of the court typically.
Right. Now, this area of evidence that you're talking about, what do you think because we know we're looking for a decision that will impact Congressional District 1 and South Carolina. What do you think the impact might be for people who live outside of South Carolina? And even in terms of using this kind of evidence in other cases to protect voting rights, what do you see the future benefits of using it?
Yeah, absolutely. So if the court ends up saying something positive about this method, then we could certainly see this method being used in additional racial gerrymandering cases, Voting Rights Act cases, other kinds of redistricting cases in other states. So, you know, in the case at hand, the stakes are limited to South Carolina. But of course, whenever the Supreme Court issues a decision, people read the decision and cite the decision and rely on the decision. And so if the court were to say, you know, we're convinced District 1 is a racial gerrymander, in part because of this computer algorithmic evidence, I wouldn't be surprised at all if lawyers and experts and litigants in other states also began to use this method. They already have to some extent, but if the court gives its stamp of approval to this method, you know, then we're likely to see a lot more use of it in other states going forward.
Okay, well, that was our final virtual comment. And how different were those three presentations? How different were those three types of evidence that were put forth and will be put forward on the day that the court meets? So I think that's a really fabulous reason to look at these briefs, and the fact that you hear not only different voices, but you hear different strategies, you hear different techniques, you hear different evidences that are presented to make the case. So, you know, really well worth your taking the time to listen to them, but also to read the briefs for yourself. So we're coming to the end of our hour, and I wanted to thank our guests for being here. I want to certainly thank our pre-record guests, because they had to take additional time out of their schedule to meet with me and do those recordings, and the fact that they thought it was important enough to make the time to join. It's a great honor. So I want to thank our historians, our political scientists, our government scholars who took the opportunity to be part of this. And I want to thank Lynn and Armand, who are here with us today. And I want to give you a chance to close with any comments that you have for people as we go forward into this week that's going to hopefully yield a historic decision.
I think the only thing I would add is what the League's amicus brief attempted to add was we're talking about what they did, and the League's brief talks about in the process what they chose not to do, which was to respect the communities of interest that are a traditional redistricting criterion. And so we went about the process of documenting what anybody in South Carolina already knows, which is that the Charleston area is one economic, social, environmental community of interest, united and quite different from the inland areas, for instance, of the I-95 corridor or of the Columbia Midlands. And so people are losing that voice, the clarity of that voice and the responsiveness of government to their concerns. And I think all of South Carolina loses because that is the one district that in the league's nonpartisan, non-racially gerrymandered maps was very competitive and would have led to campaigns that were would have been of necessity reached out to a broader range of voters than we see when districts are highly biased.
Thank you, Lynn. Armand?
Well, thank you for putting on this terrific program. I learned a lot myself. The one thing I would leave with people is that you'll be able to hear the whole argument. You know, there's no cameras in the Supreme Court, but they record everything. And so by the end of Wednesday, I think, by Wednesday night, the entire argument, the whole hour, will be on the Supreme Court's website, and anybody can listen to it.
Yes, that's true. And it's also going to be on C-SPAN.
Oh, good. Okay.
Yeah. So it's going to be on C-SPAN. So they've already got the link up. So you can go to C-SPAN and find that link, and you can request a heads up. So they'll send you an email that says, "Hey, it's on," and you'll be able to watch, or be able to watch the recording afterward. One final question for you guys. Where there's a lot of discussion right now in the public sphere about the Alabama case. Where does this compare? Where does the South Carolina compare to the Alabama case? Is it more the same? Is it adding or moving something forward? How should people think about these two cases?
They're different legally, although they're the same politically and practically, because the Alabama case was based on the Voting Rights Act, and this case is based on the 14th Amendment. And so a lot of it depends on how this case comes out. But perfectly frankly, if the Supreme Court rules for South Carolina, unfortunately, it will undo a lot of the good that the Alabama case did. If the Supreme Court goes with the lower court and sticks up for and upholds the lower court's decision, then the combination of this and the Alabama case will be very powerful in our favor, in favor of the people.
Yes, and that's where we want to be, in favor of the people. Well, I want to thank all of you for joining us today, taking a moment to sign on. Thank you so much. I want to thank Lynn and Armand. I want to thank our host, Atlantic Institute, for putting on and presenting these series where we just come to them and say, "Hey, I want to do this," and they're good. So I want to thank you so much for doing that. I also want to say that some of us will be going to DC on Wednesday, and so we look forward to being a part of this historic moment. But all of you who have worked on or signed an amicus brief, who have tried to educate the public on redistricting, who have been an attorney or a scholar working on this case, or an advocate like myself, all of you are a big part of what has to happen to make our state better. So we thank you, and we really appreciate your being here. And with that, I pitch back to Christina to close us out.